The rules of community property are not trumped by a will. A spouse can only will what he owns, and this consists of a half of the community property and a half of the quasi-community property, plus all the spouse's separate property. When the will conflicts with the community property rules, the surviving spouse gets to elect to take under the will or community property. When the will does not conflict or force an election, the spouse takes under the will in addition to community property. Upon the death of one spouse, the surviving spouse keeps his or her own half of the community property. How the half of community property held by the deceased spouse is divided depends on whether he or she left a will. In the absence of a will, the California Probate Code prescribes how the community property of the deceased spouse is divided among his or her family. If there are no children or other close relatives, all the deceased spouse's community property goes to the surviving spouse. This is added to the half already owned by the surviving spouse and means the surviving spouse now owns all the community property. If there's one child or a close relative, 50% of the deceased spouse's community property goes to the surviving spouse. If there are 2 or more children or close relatives, the share allocated to the surviving spouse drops to 1/3.